Arbitration and Alternative Dispute Resolution class. This event will be divided into 2 sessions, starting with the presentation of the materials by the speaker, which will then be continued with the discussion session regarding the materials themselves. Now, before starting this event, here are some of the rules for this public lecture that the participants needs to be aware of. First, the participants are again asked to turn on the camera and turn off the microphone during the presentation of the materials. Of course, this is excluded later when participants wish to submit questions or opinions during the discussion session. And secondly, for those who have questions on today's materials, you are welcome to directly ask these questions through the chat box in Zoom or by using the feature in the Zoom itself. Now, before we start, we'd like to do a brief photo session. And for this photo session, I'd like to hand over the session to the operator. To the operator, the screen is yours.
To all participants, currently there will be a photo session. We kindly ask for the participant to be able to turn on your camera. There are 4 slides. For the first slide, on my instruction, 1, 2, 3. For the second slide, 1, 2, 3. For the third slide, 1, 2, 3. And next slide, 1, 2, 3. Okay, thank you for your attention.
Thank you. Now we will enter the presentation session. So to Professor Loukas Mistelis, the screen is yours.
Thank you very much. So I'm delighted to be joining you this afternoon. It's a rather rainy day in London, so there's something in the climate which seems to be changing all the time. So it's not as such very summery, but at least it's good for the nature. And the gardens are very green and not dry. I will be addressing you today on what seems to be a rather sort of unclear topic. What are the 9 key features of international arbitration? Having studied or having read about arbitration, I'm pretty confident that you would have your own views as to what are the key features. What, however, I will do is I will address the topic in a slightly different fashion by providing a very brief introduction, which will lead into a definition of arbitration. And that's not perhaps the perfect or the absolute definition, but that's a working definition for me to develop by the second part of my presentation, which is the 9 key features of international arbitration. I know that we have up to 120 minutes. I might have to attend a call at work at about 100 minutes from now. So I would encourage you, if you have questions, to start sharing them already in the chat or by
Hello, Professor. Oh.
So
Your
what is my
audio cut off for a
introduction?
moment? So. Okay, it's better now.
Sorry?
Your audio cut off for a moment, but it's better now.
Okay, so the introduction will cover effectively 3 topics. What is arbitration? What arbitration is not? And is it possible at all to identify global key features of arbitration? And let's start from the first topic, which is what is arbitration? My working definition is that arbitration is a private and non-national mechanism in which the parties agree to submit a dispute to one or more third-party neutrals, typically called arbitrators, who are going to hear the parties and make a decision in a judicial-like fashion. And the decision is called an arbitral award. And that decision is final and binding. So we have effectively a very distinct sort of chain of issues that combine the arbitration. The origin of the arbitration is private, is the will of the parties to make an arbitration and to refer that to make an agreement and refer any dispute to a tribunal which will consist of neutral parties. That agreement also covers not necessarily all disputes between the parties, but certain disputes, and certainly these disputes have to be linked to a defined legal relationship. Once the tribunal has been constituted, we have the activation of the law. Most national laws provide for the rights of parties to make arbitration agreements, and once the parties have made arbitration agreements, the law provides, and also the New York Convention in that sense, and I will come back to that later, that such agreements will be enforceable. So the tribunal will work with the parties towards the resolution of the dispute, and once the dispute has been resolved, the outcome is an award. Now, this award by law and by international law as well, again, via the New York Convention, has a major legal effect and is binding, final, and also enforceable. So let's keep that as the working definition, and then start to sort of looking at to what arbitration is not. So arbitration is not a national court procedure, in the sense that national court proceedings are provided by law. One does not need an agreement to go to court. One can bring a claim to court without any agreement of the other party. And the rules of procedure are predetermined and often quite rigid and inflexible. And that's the Code of Civil Procedure or whatever system exists. So therefore, the origin of litigation is the law. The origin of arbitration is the agreement of the parties. So the difference between parties as against party power rather than legal power. And again, the level of flexibility within the arbitration is quite high. The level of flexibility within litigation is quite limited. Arbitration is also not mediation. You might be familiar with mediation as a process by which the parties agree to refer the dispute to a neutral third party called the mediator and not the arbitrator. And the outcome of the mediation is a settlement agreement, which is final, but is binding only to the extent that the parties are in agreement with it. Also in mediation, although the origin of the mediation is private, if one of the parties gets disillusioned, unhappy with the process, with the mediator, and withdraws from the process, then the process has collapsed. While if a party who has an arbitration agreement does not, as such, have the if a mediation, a party who has consented to mediation, changed his mind, that is the end. In arbitration, if a party changed its mind, then that's not the end of the arbitration. And it's interesting that in about 10% of the arbitration processes, one party doesn't participate, is what we call in default of appearance. But this does not affect the validity of the arbitration. Quite to the contrary, the arbitration continues to be perfectly strong, and the outcome of the arbitration is equally sort of binding. So in mediation, the parties control the process throughout. In arbitration, the parties control the process in the beginning, and once the arbitration has been launched, that level of control is a bit lower, but still quite significant. It's also not conciliation. Conciliation is the process by which the third party, the mediator or conciliator, takes a much more active role in the process, takes a much more active role in proposing solutions to the parties as to how to resolve the dispute. While the normal mediation is facilitative, conciliation is in most cases evaluative, in the sense that the third party proposes solutions, tries to steer the matters in one direction or the other. And last, not least, arbitration is not also expert determination. Expert determination is a process by which the parties refer the matter to an expert, but once the matter has been referred to the expert, the parties don't need lawyers, the parties don't need to make submissions. The expert uses his or her own expertise to resolve the dispute. So this is quite typical, for example, in cases that have to do with construction, where we don't have an arbitration, but we have an adjudication board, and an expert, typically an engineer, will provide an opinion which is only partially binding, to the extent that the parties' agreement, so to the extent that the parties' performance is as it ought to be, as it ought to be in accordance with the contract or international standards or not. And therefore, again, the expert determiner brings his own views to make a decision. While an arbitrator listens to the parties make submissions, and the arbitrators cannot propose solutions, cannot propose remedies, cannot propose interpretation of the facts, which are not presented by the parties or which have not been tested by the parties. So arbitration is somewhere between a court procedure and an expert determination. And it's interesting to see that there's quite a bit of range and the small details here and there which makes them different. I think it's also quite important in terms of setting the scene to be clear that there are different types of arbitration. One big distinction in arbitration relates to whether arbitration is domestic, national, or it is international. Some legal systems, for example, the English legal system, does not distinguish between domestic and international arbitration. There's one arbitration law covering all arbitrations, irrespective of whether they're domestic or international. As a result, the law appears to be reasonably detailed. There are about 100 plus articles in the English Arbitration Act. Of course, there are sections in the English style. And because this arbitration covers both domestic and international processes, is quite detailed. And in some parts, it's also quite regulatory. If we take the example of another jurisdiction, in that sense, let's say France or Switzerland, there we have a distinction between domestic law, a domestic arbitration law, and international arbitration law. In the French legal system, they're regulated one next to each other. They're both parts of the French Code of Civil Procedure. And the domestic law is quite detailed. There are many provisions, about 50 or 60, while the international law only has about 15 or 18 provisions. And in the last revision of the French law, there was even a clear coordination as to which parts of the domestic law apply to international arbitration, while it is very, very clear that international arbitration rules do not apply to domestic arbitration. And for many years, there has been also a hybrid, what is called foreign arbitration. Very few laws have that level of regulation. It's very typical in France, for example. So we have an arbitration which is being regulated by French law, but an arbitration which is not domestic and also which is not international. And it's not domestic and it's not international because the parties have not located the arbitration in any particular place. So it's certainly from a domestic front is not seen to be a French arbitration, is not deemed to be as such international arbitration, but the parties treat that as an arbitration linked somehow to the French legal order, the French seat, which however has no real connection with France. So that distinction is distinctly French. So you don't need to worry about that if you don't have that in one system. So most of the systems will be the difference between national and international, and national arbitration is often sort of fully regulated. International arbitration is very lightly regulated. Of course, you might have come across the Untitled Model Law on International Commercial Arbitration. And that's a model, is a template for a law to regulate international arbitration. And because it regulates international arbitration, again, we also have a fairly light regulation there. You will see that the particular concern of the model law is to regulate the relationship between the arbitration and the national courts at the seat of arbitration, or arbitration and the national law at the seat of arbitration. But what is very, very important to bear in mind is that the model law once the arbitration is seated in the jurisdiction, then automatically is activated. For example, a classical model of jurisdiction is Germany or Japan or Australia. So once we get to that system, then automatically the model law has been activated. The model law would apply, but the level of application or the level of interferences is quite regulated and is quite sort of limited. And that is, for example, typically in Article 5, 6, 9, etc. So most of it is supportive of the arbitration and supportive of the parties in the context of the arbitration, but will not allow a very broad interference with the matter. Then we have the distinction between commercial arbitration and other types of arbitration, particularly consumer. Commercial arbitration is there for anything which relates to business transactions and business relationship, for example, even disputes between shareholders in a single company. And the commercial arbitration is classified, regulated separately than any other type of arbitration, because it is understood correctly that the parties in commercial arbitration have sort of equal bargaining position, and therefore when they negotiate an arbitration process, there's no need to be sort of particular concern about sort of have the parties genuinely negotiated the arbitration agreement. If they have signed it, it seems to be absolutely fine that the process will be as the parties want it to be. While if we have parties which are unequal, for example, a consumer negotiating with a big business, with a big multinational, so we need to be really reasonably careful, particularly where we have the feeling that one party might have been coerced, put under a lot of pressure to sign the agreement. And that's why sort of what I will say today relates to commercial arbitration and not to consumer arbitration. So consumer arbitration, which is I put in the back, sort of in the bottom line, is these cases where we think that the parties are unequal, and therefore the arbitrators and the law might have to interfere and do some correction in the parties' agreement. One particular version of consumer arbitration is sports arbitration. In many parts of the world, athletes that want to participate in an international sporting event like the Olympics, they are obligated to have sort of signed an agreement with the federation, whether that is basketball, whether it's tennis, whether it's athletics. So if you sign this agreement with the sports federation, you cannot negotiate the terms. It's like signing an agreement with the local electricity provider or the local sort of telephone provider. You cannot really negotiate the terms. And very often these agreements have an arbitration agreement. And it's a matter of debate. And the matter, for example, is currently before the European Court of Human Rights as to whether such arbitration agreements are binding. And this comes from a particular dispute between an ice skating athlete called Pechstein, who is a German ice skater, who claims that she should not have been submitted to arbitration about a doping offense, because when she made the agreement, she was coerced into making the agreement. She did not have any negotiation position, and therefore she didn't have much of an option what to do. So that's sort of a very sort of interesting sort of variation of consumer arbitration, and expect to see more of that. Of course, we have sports commercial arbitrations. Think about, for example, for lack of a better example, and a very ironic example, McDonald's being an exclusive sponsor of the Olympics. I'm saying that because McDonald's is not necessarily the healthiest of foods, but for sports, that for many years McDonald's was a prime sponsor of the Olympics. So if McDonald's has a dispute with the International Olympic Committee, this is of course a very different type of case, is not a consumer case, it is a proper commercial arbitration, because the sponsorship, the rights, for example, about licensing, trademarks, etc., these are genuinely commercial disputes, and therefore one doesn't need to worry too much about whether we can give them particular leverage or not. And then we have also investor arbitration, or investor treaty arbitration. This is something which is, I understand, reasonably controversial in Indonesia, and as a result, a lot of bilateral investment treaties which provided for arbitration have been terminated. Of course, investment arbitration, what we have is an agreement to arbitrate which is concluded in another unusual fashion. That unusual fashion is the state makes an agreement to arbitrate a priori before a dispute has arisen. And this agreement is either in the national law for the protection of foreign investment, or in a bilateral treaty, or in a multilateral treaty. On the basis of that agreement, sometimes, not always, sometimes an investor or a private party may accept the offer to arbitrate that was granted by the state and initiate arbitration process. So on that, in that way, therefore, we have an agreement, but the agreement is not an agreement like in a classical commercial arbitration, which is specifically negotiated with a particular party, and perhaps with a prediction as to who are the likely disputing party on the other side. And that's why Professor Jan Paulson refers to investment arbitration as arbitration without privity, because there's no specific negotiation between the two parties. There's also a final point, which is rather unusual, and that's the example of mandatory arbitration. A mandatory arbitration is very uncommon. It does exist in some parts of the world, I think in the Caribbean, and it exists in some jurisdictions in relation to regulated industries. For example, if you in Greece, if you're an electricity producer by either wind energy or solar power, you have the right to sell the electricity you produce to the national grid. But because the national grid is owned by the government, and the terms of that sale of electricity might be on terms which are sort of regulated, regulators and sort of energy producers are in an exclusive and mandatory arbitration agreement. Whenever they have a dispute, that dispute would have to go to arbitration, and that's a sort of an arbitration which is being resolved by a number of pre-approved arbitrators because of the level of expertise that is required and so on. So in some of the regulated industries, telecoms, energy, we might have some of this mandatory arbitration, but it's rather uncommon. I also perhaps to say that consumer arbitration is objectively very uncommon too, with one exception, and that exception is the United States. In the United States, we have every year a report of about 60 to 65,000 arbitration cases. Out of the 65,000 cases, about 63 are consumer cases. So in the US, a very large number of arbitrations are consumer cases, and therefore are not binding. So they're binding only if the consumer is prepared to accept the outcome, but if the consumer does not accept the outcome, can go through the arbitration and later can go to the national courts or any other mechanism. In Europe, particularly in the European Union, it's not possible to have consumer arbitration. The consumers are protected as weaker parties. So even if there are agreements to arbitrate with consumers, these are not enforceable. They're optional. For example, England, if you buy a travel, sort of a hotel and accommodation and flight, to the Association of British Travel Agents, there's the option of going to arbitration as a consumer arbitration, which is a scheme run by the Charter Institute of Arbitrators. If you buy certain cars from some manufacturers, there's also the option of consumer arbitration, but this is optional arbitration, therefore not what we cover. I would also like to make the final comment on this slide on the investor arbitration, that we often refer to investor-state arbitration as ISDS. Of course, investor-state dispute settlement. ISDS as a name is much broader than arbitration, but is often used as a synonymous, in my view, wrongly. Now, I wonder whether there are any questions before I move to the next few slides, which are a slightly different thing. So are there any questions about categorizations and the types of arbitration? And as you know, you can post questions in the chat, or you can raise your hands, and I think you can raise the hands by going to the reactions part and find the hand to raise. So if there are not questions, I'm happy to continue, and I will come back to questions in this part before we move to the next part. One of the interesting things about arbitration is you have to close your eyes and think of a national courtroom. In the national courtroom, typically the judge sits a bit higher than the rest of the parties, the audience and the litigants. And often the judge has in the background a formal coat of arms, something that shows that in that sense that the judge possesses authority, the authority of the state. If, however, you want to think about how an arbitration would look like, it would look, first of all, is horizontal. Everyone's on the same level. There's no one sitting higher than the rest. And very often it looks very much like a conference room. But often the room will not have a sort of a circular table, although I do like sometimes to have circular tables in my arbitrations, but it will have sort of a horseshoe shape. But there's no difference of position between the tribunal and the claimant and the respondent. And that's because the power of the arbitrator comes from the parties. Another, of course, peculiarity of arbitration is how it has been regulated. And we call that a layer cake. So in arbitration, what we will see very often is that we have multiple laws relevant. We have the law that governs the substance of the dispute, the law governing the merits, the law of the contract. This is what is most often chosen. I think in about the International Chamber of Commerce suggests, or the cases that they look, that almost 85% of the cases that go to the ICC, the parties would have chosen the law to govern the contract. But they would not normally have chosen the law to govern the procedure, what we call the lex arbitri. And therefore, when it comes to the law governing the procedure, that is sometimes the law of the seat, sometimes the law of the contract. So if there's a law governing the contract, we assume that it might govern the procedure as well. Although we often say, and correctly, that the arbitration agreement is a separate agreement from the contract in which it is contained. Because the contract, the substantive contract, is a contract that deals with the rights and obligations of the parties, substantive rights and obligations of the parties, while the arbitration agreement is a procedural agreement which takes the disputes outside the courts and brings them into the arbitration. And therefore, the contract is governed by sales law, the civil code, or something of sort of a domestic law, while the procedure is governed by a number of other things. It could be governed by the arbitration rules of the institution the parties have chosen, will be governed by the law of the arbitration law of the seat. It could be governed by soft law like the IBA rules on taking of evidence and the like. Then we have a third layer, and that is jurisdiction. looking effectively at the law governing the arbitration agreement and the power of the tribunal to make a decision. And this is something that I'm not going to address today, of course, but it distinguishes arbitration from domestic law and domestic court scenario, because in domestic court we distinguish between substance and procedure. But in arbitration we have three categories. We have substance, procedure, and we have enforcement as well later. Sorry, jurisdiction and enforcement. So jurisdiction, the capacity of the party to make an agreement is a matter of the law of that party. So if we have a contract between an Indonesian company and a Japanese company, we have to look at the Japanese law to see whether the Japanese law allow that particular party to make an arbitration agreement, and also which employee of that party has the authority to sign the agreement. And when we come to the Indonesian party, we have to look at the Indonesian law to see whether that party has the right to enter in the arbitration agreement. And if it's a corporation, which officers of that corporation have the right to make an agreement on behalf of the company. When it comes to subject matter of the dispute, we look at arbitrability. That's also a question of jurisdiction. What disputes may or may not be referred to arbitration. So last not least, we have enforcement. So a lot of different sort of laws come into place. But if we are trying to make an attempt to identify sort of some key features, and that's not our 9 key features that we're going to be discussing. So what seems to be the case is, first of all, that arbitration is private and non-national. So unlike national court, the arbitration does not play in public, it's behind closed doors. And the origin is not state or public law, but it's private law. It might go even a bit further sort of as well. Then arbitration is generally consensual. Even when it comes to investment arbitration, arbitration is consensual because the parties, the state and the private party have at some stage agreed to arbitrate, and this agreement is critical. Then arbitration is adjudicative, so it looks in some respects like a court proceedings, and therefore the arbitrator would make a decision very much like a judge. Will hear both parties, will weigh the evidence, and provide a reasoned decision, not just make a decision. For example, in the expert determination, we don't have a reasoned decision. That's another difference between arbitration and expert determination. And finally, the outcome is binding and final, and we come back to that a bit more as we go further along. So if there are not any questions, I would like to ask you then a question. Why would then one go to arbitration? We have the national court system. We know how the national court system operates, and we are reasonably confident that the national court system can provide a fair assessment. Of course, there are jurisdictions in some parts of the world where the feeling that the courts might be corrupt, or the judges rather might be corrupt, or the judges have prejudices. So, for example, if you're a foreign party, you might be quite reluctant to bring a claim in a national court because you think if you're suing a local party, then you don't get the same chance. But what would be the main motive to go to arbitration? And now, I don't know whether any of you would like to offer his or her views on that rather basic question. So why would we go to arbitration?
To participants, Jesslyn, you may unmute and answer the question.
Okay, thank you, Dari. First of all, I want to apologize. I couldn't turn on my camera due to the signal, but I believe the reason why most, especially businesses choose arbitration is because it's a lot safer, as in the proceedings is and the decision also binding and less complicated. Thank you.
So what is, sorry, the sound was a bit low in the beginning. That was my fault. But you said from the business perspective, one of the points that you made that is quite interesting is that it is safer for parties to go to arbitration. Meaning what?
I believe when providing an evidence, in arbitration there is this like confidential. So and the proceeding also closed doors, not public like in court proceedings.
Okay, thank you. So then I have Jesslyn.
And I believe previously Hanora raised her hand. So maybe you want to answer as well, Hanora?
Yes, Darian, thank you for your time. Good evening, Professor. I would like to address some of my answer to the why the parties in arbitration choose to use arbitration is based on efficiency, privacy, and also neutrality. For the first aspects, it's about efficiency because arbitration does not have a long process like ordinary court. Like there's no banding atau kasasi, and then the privacy aspects probably remain probably because the confidentiality is the main value of arbitration, where arbitration is a confidential procedure because all the hearings and arbitration are restricted because the media or the public cannot attend any procedural events in arbitration. And then for the neutrality aspect, I think that the parties to an arbitration are able to choose the applicable law, the language, and also the venue of arbitration. Because this allows the parties to equally advantage to this allows the arbitration to equally advantage to both parties. Thank you.
Thank you. So yes, I mean, you're right, there's no appeal, and it's interesting that you make the point of efficiency, which is a matter of broader debate. Of course, efficiency is a relative term. I mean, I'm not sure what is the average duration of court proceedings in Indonesia, especially if one has to go through 3 instances. For example, in England, depending on the type of case, you can go through the 3 instances in 2 to 3 years. I think in Japan, you could go through 3 instances in about a year and a half. But in countries like India or Italy, you might take you 15 years to go through 3 instances. So that's in a very relative term, but certainly efficiency is important. And I also note again that you made a very strong point about confidentiality and why that's important. So Darin, we have a few hands, I think. Who is next?
Okay, if you're still opening, then previously Adiana raised her hand. If you would like to answer, Adiana, feel free.
Well, yes, Darren, thank you. I would like to answer your question, Professor. Actually, I have an idea that why some private entities, which is the business entities, would like to choose arbitration as the place, as the forum to dispute settlement, because where they have the right to choose which arbitrator that they would use in dispute settlement in arbitration. And in arbitration dispute, it's very common to find that there are specific issues that need to be assessed by someone that is expertise in that matter. So for instance, such as intellectual property or maybe in medical issues. And that's why probably that the reason why some business entities want to choose arbitration as a dispute settlement.
Of course, I mean, choosing your arbitrator is a significant element of confidence in the process for the parties. And as you say, very often we have the sense that there is quite a bit of expertise, and therefore that's also a very important aspect. And Darian, who is next?
I think that's all for the one who raised
very
their
good.
hand.
So I think I'm quite intrigued by the points you have made, and I would like first to address this point, because there's a lot of different options that parties have, what we describe often as horses for courses. And you'll see, for example, that in this dispute resolution continuum, which starts from green to sort of red, we started with negotiation, which is something that the parties can meaningfully do on their own. There's a dispute. One manager calls the other manager, or Zooms or Teams, that person, and trying to resolve a dispute without having to go anywhere else. Of course, in some cases, negotiation is done by independent negotiators. That's for very big contracts. For contracts with, it's difficult for the companies themselves to talk directly. Then we have mediation, which, as we've seen, we have a neutral third party, but the decision is not is binding, but is binding as any other contract. If the parties don't want to sort of comply, then the process will have to go to arbitration. In arbitration, and that's very important, the process is binding once you have entered that process, and the outcome is binding. But there's a level of flexibility. You choose your arbitrators, you can choose different institutions, you can choose different seats. So there's a level of flexibility. And last but not least, we have litigation, which is predictable. We know what's happening, but not much flexibility. So we call ADR negotiation and mediation. The Americans, of course, call ADR arbitration as well. But I will call the arbitration and litigation effectively adversarial processes. That's why, in my view, arbitration is an alternative to litigation, but arbitration is not an alternative to mediation. That's a different process. And because, of course, when we look at negotiation and mediation, what we have is a consensual process, which is based on interest rather than rights, and is generally confidential. So confidentiality is something that has been raised already a couple of times, maybe 3 times. But if it is, then obviously negotiation and mediation is where you ensure most of the confidentiality. Now, if we look at this continuum, the further away you move from negotiation, the more time and resources will be used. A typical mediation is 1 day, sometimes 2 days, and then you have an outcome at the end of the 2 days. Perhaps you might have a month to prepare. A typical arbitration is about 18 months, sometimes 15, but never less than that, unless you're in an expedited process. And litigation, you cannot really dictate the timetable. It takes a lot of discussion. So the more you move to a direction of litigation, the more time you spend on the dispute, and the more resources you expand on dispute. And also, the further away you are from litigation, the more control you have as a party, the more ability you have to design the process as you want. So therefore, the feeling is that arbitration is all about choice, choosing arbitrators, choosing law, choosing seat, choosing whether to go to ad hoc arbitration or institutional arbitration. So it's a matter of choice. It's also a matter of confidence. It is a process that is designed by the parties and with the other party and the arbitrator once the tribunal has been constituted. So the trust of the parties in the process is sort of addressed through regular discussions throughout the process to make sure that you get to a process that everyone is happy with. Is an autonomous concept, is in parallel to the arbitration world, is not about to the litigation world. In most, an English arbitration should not be seen as a sort of a version of English litigation. This is a different universe, is a parallel universe. And last but not least, one would hope that arbitration is all about quality. So parties use the right type of case, the right type of arbitrator, and they get therefore the expectations they would like to have so that the process can be really sort of have an outcome, a very positive outcome for everyone concerned. So the quality of the arbitration is critical, because if arbitration doesn't have the right level of quality, then we cannot get anywhere, and so and therefore that would be too complicated. So arbitration relies on quality, and the better the awards and the better the arbitrators, the better the arbitration process. If we have no quality, we have no legitimacy. So I ask you the question, why would you go to arbitration? And I will give you my version. First of all, is an alternative to national court. There will be circumstances where a foreign party who has a level of suspicion or of mistrust of national courts, and therefore you try to go somewhere else. And if you have parties from different jurisdictions, no one wants to go to the other party's court. And I gave you the example of a dispute between Indonesian parties and parties from Japan. Naturally, an Indonesian party would not go to Japanese courts. Of course, Japan is also a common law jurisdiction, but perhaps a bit more Germanic, is a bit stricter. The language is different. You need to have locally qualified lawyers. And similarly, a Japanese party would not like to come to Indonesia, as nice as a place Indonesia might be. You need to have locally qualified lawyers. You need to have your own lawyers, and you don't know how the process operates. So in such a situation, to agree to go, for example, to arbitration in Singapore or in Hong Kong, perhaps Singapore now rather than Hong Kong, or if the parties so wish in Shanghai or in Dubai or Thailand, in Bangkok, is an entirely matter of choice. The second important feature in my view is that arbitration is final. And the point has been made that there's no appeal or cassation. So it's a one-stop. You've gone, you've taken the risk, you've chosen your arbitrators. The outcome of the decision is something that you cannot really tamper with. You cannot appeal to a higher authority. You have to accept the outcome. And the outcome of the arbitration is also enforceable, and is enforceable in more than 160 jurisdictions because the New York Convention has that validity. It's also a very flexible process. If the case is small, you can dispense by document production or unnecessary matters. If the value of the dispute is very important and the stakes are very critical, then you might design a process which is much more elaborate and sophisticated. So you can do small cases, you can do medium cases, you can do very high value cases. In my own arbitration practice, I have acted as arbitrators in cases, the smallest of which was about $40,000, and the largest was $8 billion. So in the $40,000, you agree that everything will be done on paper, you will dispense of certain matters, and therefore you try to be efficient and while also being flexible. And of course, if the dispute is 8 billion, the parties can decide a process that is much more complex. And the nice thing about arbitration is you can't do that because the process is not rigid. So you can sort of play around and sort of, you can sort of think of how to organize the arbitration. While in litigation, you don't really have the choice. And therefore, in arbitration, for every single arbitration, given that you have different tribunal and different parties and different lawyers, we design a bespoke process, very much a bespoke process. And one of these matters where sort of this is particularly sort of relevant is if you look at evidence, witness discovery, document production, and so on. So you can't decide what works in the circumstances for the parties involved. Now, of course, as part of the advantages, party autonomy we have mentioned, the expertise of arbitrators, the right to choose of an arbitrator, but there are also some what I will call alleged advantages. you have talked quite a bit about confidentiality and privacy. The reality is that the arbitral process as such is private, in the sense we do not know very much about the deliberation of the arbitration tribunal, and parties which have no connection with the dispute and the parties involved in the dispute will not have access to the process. What we have seen, however, in the last perhaps 15, 16 years, maybe it was a bit more, is that we see more and more that there's public information about certain types of arbitration. If you subscribe, for example, to Global Arbitration Review, you see that there's quite a bit of discussion about certain cases. How do we know about that? There are two options, either because there have been some court proceedings related to the process, or because one of the lawyers has gone and talked to the press, or one of the parties has gone to the press, or because you have a listed company, a company listed in the stock exchange, and that company has obligations to report to the shareholders about the existence of the disputes, and in this sort of reporting process, the existence of a dispute and certain informations have been sort of disclosed. Of course, that's a limited level of disclosure, and it has been a bigger debate ever since a case called ESSO Petroleum, and Sidney Plowman, who was the Minister of Energy in Australia, as to whether arbitration is genuinely confidential if the law doesn't say anything about confidentiality, or if the arbitration rules that the parties have chosen don't say anything about confidentiality. So when it comes to confidentiality and privacy, yes, arbitration is privacy, but what is confidential, which means there's a legal protection of the process, so no one can get access. This is only relevant if the applicable law and the applicable rules say so, or if the parties have made an agreement. And of course, the bigger question is that if it's not the case, then this agreement will not be enforceable. There are certain arbitration institutions, for example, LCIA, where all arbitrations have been very sort of confidential. I think in the history of LCIA, perhaps only one or two arbitration awards have ever been made available to the wider public. The ICC has a confidentiality provision, but the ICC has moved to a level of transparency where some sanitized version of arbitral awards are being published, not indicating the arbitrators, not indicating the lawyers, not indicating the parties, but certain sort of data will be available. And we move to a period of transparency, and therefore bear that in mind. So then we have the element of speed. As I told you, that's a relative point, because we need to know what is the frame of reference. So the LCIA average 18 months, ICSID dispute average 4 years to 5 years, ICC perhaps about 18 months. And then so you have to compare it with your perception of speed of your own sort of court proceedings. Then, of course, cost is another matter. Arbitration is not inexpensive. And arbitration is not inexpensive because in some respects, arbitration can be described as a luxury market. I mean, if you were coming to London for that talk, for that lecture, you could arrive at Heathrow Airport from Indonesia, and then you could take the public transport, that is either a bus or the underground, the tube. That will take you to the center of London for about £4 or £5. It can be very crowded, it can be very slow, there can be a strike, as there is a strike today, for example, and therefore you cannot really go there, or you have to wait until there's an available train. But that's what is the equivalent of the National Court. It's what is provided to everyone by the state through the taxation system with a very small additional pay. But then you can use sort of the alternative, like the arbitration. You can take a taxi, but the black taxi to take you from Heathrow to central London might cost you sort of 60, 70, 80 pounds. You can perhaps discuss the route. And there are alternatives to taxis. You can take Uber or Bolt or any of that. So these are forms of arbitration, again, which are supposed to be competing with the ICC or the LCIA, which is the black cab, or you can take helicopters. I mean, that's the extreme case, or a limousine. So arbitration is not the public transport, it's the alternatives to the public transport. And therefore, all of them come with a cost. But it might be that it is safer, it's more comfortable, more private to use those. And that's why you opt for those. So I don't know whether there's any questions here. Otherwise, I will move to the final part of my presentation, the 9 key features. If there are no questions, then I will move forward. So again, don't forget, we said that the limitations that we talk about international cases, not domestic, and commercial cases where the parties have agreed to arbitrate. So the 9 key features that I will present is privacy, consensual. You see, I use the word private rather than confidential. Consensual, which is a given but has variations today. Arbitration is a party-driven process. It's a process which is lightly regulated, not unregulated, but is lightly regulated. It's flexible, is non-national, is binding, is enforceable, and last not least is democratic. And the democratic point is a fairly new issue because it has to do quite a bit with the diversity and the development of arbitration all over the world. Let's start, therefore, with the first part. Arbitration, the private, which already we have addressed, indicates that arbitration is not in the public domain. It happens, that is, behind closed doors, and that is undisputed. It also may imply, but does not automatically imply, that the process is also confidential. The confidentiality is sort of a bigger sort of question because you have to look applicable law and applicable rules. Therefore, for the privacy and confidentiality, we have to look at national law, arbitration rules, and practice. For example, English law takes the view that arbitration is by nature confidential. And therefore, in some cases, even court proceedings associated with arbitration will be confidential. But that's a common law tradition. It's not as such the English Arbitration Act. The LCIA rules say that same, but the English courts would use it even for an ad hoc arbitration taking place in the jurisdiction. So that's almost uncontroversial. Second key feature is the consensual nature. So if we have no agreement of the parties, if we have no consent to arbitration, there can be no arbitration. But looking at practice, then we have quite a bit of variations. We have to look at what is the evidence of consent, what is the indication of consent, and what happens when we have a non-signatory party which clearly gets a benefit out of the process, or sort of has some interest in the process. And one good example to bring here is a single case that I will mention briefly, and this is the case called Dalla and Ministry of Religious Affairs of Pakistan. In Dalla, we had a Pakistani, so we have a Saudi Arabian construction company which entered into an agreement with the Ministry of Religious Affairs of Pakistan with a view of creating accommodation for people from Pakistan who go to the Hajj and pilgrimage in Mecca. The government of Pakistan, the Ministry of Religious Affairs, negotiated a contract with Dalla, but the contract between Dalla and Pakistan was not signed by the government of Pakistan, but it was signed by a trust that the Ministry of Religious Affairs has created. And that trust has been given the amount of money that was the agreed price. The Ministry of Religious Affairs negotiated with Dalla, effectively did everything, and a lot of the paperwork was done through a letterheaded paper of the ministry. Of course, if sometime later when the construction was completed, as typically in construction cases, the process were run over the deadline, and it was more expensive than the price, what was agreed. So Dalla tried to recover some additional costs, and when they tried to recover the cost from the trust, it emerged that the trust had been dissolved because the trust was in the hands of the government. And therefore, DALA brought a case under ICC rules against the government of Pakistan. The tribunal assumed jurisdiction over the government of Pakistan, saying that the government of Pakistan and the trust fund were indistinguishable. There was effectively an emanation of the government, and there was clearly economic unity and control of the trust fund by the government, and therefore no hesitation to bring that claim against them. So DALA then tried to enforce the award in the UK because there were more assets of Pakistan in the UK rather than in France. And the English courts took a very traditional approach. That was the English Supreme Court. They said, look, the Ministry of Religious Affairs did not sign the agreement. The Ministry of Religious Affairs didn't clearly protect itself, limit its liability by creating the trust fund. And that was known to DALA. Therefore, non-signatory, no consent, no arbitration. And even if there's an arbitration, that award cannot be enforced because in the eyes of the English court, there was no jurisdiction. Then DALA went to France a few months later and had the award enforced in France because the French court had a different view as to sort of the parties to the arbitration. And the signature for them is not entirely critical if there was if the government and the trust fund were indistinguishable. So we see two different sort of walks of life, and of course there's a lot of case law these days that looks at cases where non-signatories can be sued in arbitration as if they were parties, because in these cases, although we don't have express consent, we try to find that there's either implied consent or constructive consent. So the evidence points to the existence of consent. And that's a sort of a very interesting sort of debate. Of course, we have issues of consent in ISDS cases as well, which some of them are commercial cases. And we have also issue of consent in sports cases. I mentioned the Pakistan case in the European Court of Human Rights. Third key feature is that arbitration is party-driven. Without parties initiating arbitration, there can be no arbitration. And parties have quite a bit of control of the arbitration. Therefore, once arbitration has been initiated, there's not much scope for national courts. There's not much scope for the national law. So, in other words, one could argue, and that's a bit controversial, that the parties own the arbitration. It is the parties' arbitration. But when we say that about the ownership of the arbitration, I would like you again to use a metaphor, if you mind, sort of imagine, by not necessarily closing your eyes, that arbitration is a boat, a ship, or a vessel. It is owned by the parties, but the tribunal is the captain. And therefore, the captain of that boat, of the ship, has an obligation to make sure that is navigating in safe waters. So the captain make decisions sometimes which are not in accordance with the will of the owners of the parties, because that's the safe thing to do, is either to protect due process, and due process and observance of mandatory rules is the most important function. Now, this observance of due process and mandatory rules, these days, for example, is quite one classical example is sanctions against Russian parties in arbitration. So an arbitration tribunal, though it has jurisdiction, might tread very carefully before they fully assume jurisdiction over a matter that involves a party which is sanctioned. Because even if the other party is successful, the award might not be enforceable, but other tribunals will take the view that they can proceed with the arbitration, because even if the award is not enforceable, that's a risk that the parties are assuming or are prepared to assume. So yes, the parties own the arbitration, but the arbitrators are in the steering wheel. So we say that arbitration is also lightly regulated. It would be wrong to say that arbitration is completely unregulated or deregulated, because it is not. The majority of jurisdictions will have an arbitration law. A few years back, I think in 2006, I was in your region drafting the first ever Cambodian arbitration law. Before 2006, Cambodia did not have an arbitration law, and I was entrusted by the Asian Development Bank and the German for International Development to draft the arbitration law. And the current law is largely my recommendation, with some interferences rather than suggestions by the Ministry of Commerce in particularly appointing and accrediting arbitrators. So, of course, arbitration existed most likely in Cambodia, perhaps not as developed before the law was drafted, but almost every country, even those countries which do not have a law, gradually get a law. We have a number of different regulatory modules. One of these regulatory modules is the Untitled Model Law, which is the law in some 70 or 80 jurisdictions, perhaps even more these days. And that is a sort of a model that has been developed by the UNCITRAL, the United Nations Commission on International Trade Law, and which regulates only international arbitration and regulates in international arbitration in a light touch way, effectively by regulating the relationship between national courts and arbitration tribunals, and also regulating when a national court may interfere. So that's one example. That is the very regulated relationship between the national court and the arbitration. But the model law does not as such regulate arbitration. So there are very few provisions that really go to that in the model law. The other model is the English Arbitration Act. The English Arbitration Act from 1996, the model law is to be drafted in 1985 with some amendments in 2006. So in the English Arbitration Act, once you have landed onto English arbitration, onto England to have your arbitration, the view is that the English courts have sort of a residual jurisdiction. There is no sort of regulated sort of relationship, but once you land it here, the English Arbitration Act applies, and the English courts have a supervisory authority. Now, if you look, however, a bit closer in the English Arbitration Act, it's not as scary, that is always there, because in Section 4 of the English Arbitration Act and in Schedule 1, it's clear that some provisions of the Act are mandatory, some of them are not mandatory. If they are not mandatory, you can more or less forget them because they're default provisions. And even if you look at the mandatory provisions, you see that the going to court is a matter of choice by the parties, but no obligation. So the courts are there to support the process, but they're not there to interfere with the process. So the courts will not be activated unless the parties request that activation of their own. And the third model is France, Switzerland, which is generally a hands-off approach. Let's not do anything until the tribunal has been constituted and had an opportunity to make a decision. So regulated intervention, no intervention, and residual intervention is the sort of the three models. What is important, however, to mention is that 2/3 of the arbitration seem to be going to England and France, Switzerland, and 1/3 seems to be going to the Untitled Model Law. So we have almost a concept of horses for courses. People use different models because either that's what they were familiar with, or that's what they are wanting. So, but all of these models are relatively light in the regulation. And if there's a distinction between national and international, international arbitration is even lighter, even more lightly regulated. The fifth key feature, the flexibility. arbitration is flexible because it works on the assumption that not one size fits all. So different sort of different models of arbitration: ad hoc, institutional, expedited, simplified, not simplified, 3-member tribunals, 1-member tribunal. There are different styles, more adversarial or more inquisitorial, depending on whether you want to give the tribunal a bit more power in how to conduct the process, or less power how to conduct the process. And different institutions have different models, and of course different seats have different features and different characteristics. For example, a lot of arbitration in England, the expectation is you're going to have a court reporter. It comes normally with a package. You might not get that, for example, in some other arbitrations where primarily there's a focus on looking at sort of a recording, but not a full transcript. Yes, I think that's all I want to say on the flexibility. Oh, arbitration also not non-national. Yes, arbitration tribunals have a seat. Yes, arbitration has a seat, but arbitration does not have a nationality as such. I mean, an arbitration which is seated in Singapore is not, strictly speaking, a Singaporean arbitration. And an arbitration seated in Dubai is not necessarily an Emirati arbitration. The seat is a way to activate court support where you need it. But the evidence is that almost 90% of the cases do not interact with local law and do not interact with local courts. So this is a sort of an insurance policy to have at the seat of arbitration, but it's not something that is always being activated, because the seat might be completely irregular. And if you are in some place like Switzerland and France, there will be really no activation whatsoever. In this particular point, and I'm only going to cover it sort of lightly here, but as you get the slides, you're going to have the slides and be able to read a bit more on these resources. I'm using as particular point of reference the late Professor Emmanuel Gaillard, which has a book called Three Philosophies of, an article called The Three Philosophies of International Arbitration. It also has a book called The Legal Theory of Arbitration. So he says that in arbitration, there are effectively 3 competing philosophies or representations. The first one is one that equates the arbitrator with a local judge at the place of arbitration. So if an arbitration is sitting in London, he must act like an English judge. And therefore, the source of power of the arbitration is the English law, the seat of arbitration. He calls that theory the monolocalization theory, and it's certainly true to some extent in relation to English law. Then he says there's a second representation, which is a Copernican revolution, apologies for the typo here, vis-a-vis the first, that is, the process through the end result creates sort of an award which is recognized in a few countries. It's on the basis of that recognition that the seat doesn't matter as much, because what matters is that the award can be enforced. And unlike a judge, the arbitrator does not have a local law and local authority. He calls this process Westphalian because it's based on the model in which each state decides for itself the conditions under which the process would be legitimate, and under which an award might be recognized. So it looks at the level of community, and that international community accepts the award and accepts the outcomes of the award. The third theory, he says, is an arbitration which is effectively emancipated and reality. So this is what he will call a transnational arbitration. So, and says if the origin of the arbitration is the agreement, which is a private agreement, that's all you need for the validity and legitimacy. And therefore, arbitration is a transnational legal order, not necessarily linked to one or the other place. And that's sort of a link to the main book. He has the Legal Theory of International Arbitration, which is effectively his Hague Academy lectures. So 3 different models, not necessarily coinciding with the regulatory models, but this is more about philosophy and legitimacy of arbitration and where we are moving. So next, of course, the seventh characteristic is arbitration is final and binding. So once you got an award, there's no appeal, with very, very few exceptions in very few jurisdictions, in some commodities, for example, and in some investment arbitration models. And therefore, arbitration is a one-stop shop. So no sort of much more sort of nothing more to do after the arbitration is finalized. And arbitration is also binding on the parties. And given that arbitration is binding to the parties, then there's no act to sort of ratify the outcome. Therefore, arbitration awards can only be annulled for very limited reasons. And this is typically either for breach of due process, but manifest breach of due process, lack of jurisdiction, or a breach of public policy. The penultimate feature, arbitration is enforceable. Now, why is it enforceable? Because of the New York Convention, the 1958 New York Convention, that tells us that our arbitral awards will be enforced. And it's interesting to see that map of the world, how many jurisdictions have are blue. So the blue are the New York Convention. That this map is a bit older, have not had. So if you look at here, Turkmenistan has recently ratified the New York Convention, and therefore we have fewer and fewer countries, and actually a couple of more countries in Africa have gone in that direction. So it seems to be almost a universal map of the world where almost every country agrees that that's the right thing to do. And as I say, that's unfortunately a bit of an older map. There would have been even less here, less gray. So the new convention says, very simple convention, about 12 articles. If the arbitration is based on an arbitration agreement, which meets the criteria of an enforceable arbitration agreement, then the award would be quickly enforced, because it has to be treated as if it was a judgment of a national court at the highest instance in the enforcing court. And of course, the new convention deals with the enforcement of primarily foreign arbitral awards, but there's nothing wrong in that sense about having that even for domestic awards, and some jurisdictions have a similar system. Now, the final part, so that arbitration is democratic, and this is perhaps a part that needs a bit more explanation. That's why it will take a few more minutes to get to that element, to that discussion. What does it mean? What does democratic mean? So, of course, democratic in the classical sense, in the Greek sense, if you want, is every citizen has the right to vote. Every citizen has the right to be voted for. And in this respect, one person, one vote. No one is more important than anyone else. That's a very strong confidence sort of system, because you have to accept that everyone is in equally good position, and bear that in mind. So how that is really been sort of developed here, and how we can see that. So this democratization, that everyone is equal, everyone can be an arbitrator, everyone can be a judge, everyone can be a party to everyone can be represented by whoever they want, requires a very high level of confidence. We have to trust each other. And that's the very important aspect in arbitration, to gain both legitimacy, but also to work more about diversity. So yes, we might think that an arbitrator from our own jurisdiction, because has the same color skin as we have and has gone to the same university, and similar school system and speaks the same language or has the same accent as we have when we speak English, we think that this arbitrator is better than other arbitrators. But the whole thing about democratized arbitration is that we should never have these thoughts. We should think that somebody who is reasonably well trained to do the job, we should have the confidence that they can do the job, and that's the end of the story. So is that only a matter of an advantage, or there are disadvantages about arbitration being democratic? Arbitration being democratic means that everyone, even those who have never had an arbitration before, can go to arbitration, and they can bring anyone to represent them, not necessarily somebody who is trained in arbitration, not necessarily somebody who has experience in doing arbitration cases. And because arbitration is democratic, we have to accept it. Some of these people will come with a lot of baggages. The baggages they have, the prejudices they have, the biases are their domestic court proceedings. So we need to be thinking outside the box. We have to be thinking about how arbitration will be different from our domestic court proceedings and be prepared to be challenged. And that's why a reasonably experienced tribunal will work with the parties, will educate the parties so that they can sort of get to the sort of a process that is satisfactory and is enjoyable by everyone. And that's a key significant sort of aspect of how arbitration can work well. So democratization therefore means that we have a much bigger pool of counsel, lawyers, some of them with no experience or no international experience. It also means that we have, as part of that, entering into a community of lawyers who work in arbitration, where people forget that there's a lot of soft law rules which have been developed by the arbitration community. I mentioned the IBA guidelines on the IBA rules of taking of evidence. And that's something that has been developed by the arbitration community, but somebody who is a new entrant into that process, a new person in the process, might not fully understand how that works and why we should accept it. And therefore, we have to be very reasonably careful. Again, as I say, the educational role to accept that somebody might not have had that level of experience and try to get them together to be in the same sort of level that we expect everyone to be. So in my view, democratization is actually the answer to diversity. If we think that arbitration is not very diverse, then this is the way to make arbitration diverse. It's a matter of trusting each other. It's a matter of getting to understand the needs of every party and try to get to a proper understanding of where we want to go and where we want to develop arbitration. So diversity will create effectively a bigger pool of arbitrators, because with the way arbitration or institutions see diversity at the moment is in a very mechanic way. They see arbitration as having this percentage of arbitrators being women, but they don't say anything about people coming from the developing countries. What level should we be satisfied that arbitration is democratic if Indonesian arbitrators feature in the top 10 of most popular arbitrators? You have a very populous country, but you have very few arbitrators who are operating globally. Therefore, it's critical for us to make democracy work, and we need to work experienced and less experienced arbitrators in creating that sort of dialogue, creating this training, and creating this capacity for people from developing countries to grow there. Because arbitration, when it's democratic, will also bring expansion. So an expansion is both in terms of geography and in terms of subject matter. For example, a lot of arbitration countries have had the first arbitration laws in the last 20 years. I mentioned the example of Cambodia. Another example is Brazil. Brazil has not had a proper arbitration law for many years, A law was developed in 1996. It was challenged in the Constitutional Court until 2001. And now Brazil is one of the countries with the largest number of arbitrations, domestic and international. So other countries, of course, have significantly updated their arbitration laws. And I speak about Latin America, particularly Central Asia, Southeast Asia, Singapore, in your neighborhood, sort of Hong Kong, Japan have been trying really to update and modernize the arbitration law to the extent possible. The same is true in India. We also have a proliferation of arbitral institutions, many more institutions, a lot of regional institutions. I do not know very much about Bani, but I know it's a very sizable institution. But you've seen, for example, that Singapore, Hong Kong are doing incredibly well in terms of numbers of cases. And at the same time of the scope of arbitrability, we now have covered disputes which were not going to arbitration before: fintech, financial disputes, technology, media, telecoms, blockchain. Even disputes with insolvent parties are often being arbitrated these days. So we have seen a very significant growth, and it's important that the younger generation of arbitration lawyers are part of this growth. So this is effectively what I wanted to present to you as the 9 key features. And as I indicated, I will only have about another 5 or 10 minutes for questions, and I will be happy to take any questions. The slides would be made available to all of you, and questions can be, as Darian was suggesting also in the chat, either be submitted in the chat or can be submitted by raising your hand. And as I said, I have unfortunately only about another 10 minutes, but I'm happy to take questions in that frame. The slides will be made available to you after today.
Okay. Thank you, Professor, for your explanation of the materials. We will now be entering the discussion session. As mentioned previously, we invite all the participants to either post their questions in the chat box or use the raise hand feature and directly ask that question. And I see that there's already one question. So to Gregory Joshua, the floor is yours.
Thank you so much, Darian, for the opportunity. Thank you so much also to Professor Loukas Mistelis for a very insightful presentation. It was, and I would like to ask about the question in regards to the procedural steps of arbitration itself. I have done a small research, maybe also related to one of our assignments at class about Indonesian Arbitration Act. So because previously you also mentioned about international investment arbitration, which is also a very, very great concept in arbitration, I think. But one of the articles in Indonesian Arbitration Act mentioned that an international arbitration award in which the Republic of Indonesia is one of the parties to the dispute may only be enforced after obtaining an order of exequatur from the Supreme Court of the Republic of Indonesia. And I think based on small numbers of articles that I've read, the enforcement of investment arbitral award in the jurisdiction of the host states is sometimes political, because it is sometimes related to the national interest of a country. So I would like to ask your opinion about this kind of article, which requires an exequatur letter from the Supreme Court in order to be able to enforce such investment arbitral award. Because as we know, there are cases where investment arbitral award cannot be enforced. Maybe not in Indonesia, because Indonesia's government has also have a good faith in enforcing for investment arbitral award. But I think there may be a loophole in this current Arbitration Act that must be fixed or revised in the future. So I would like to ask your opinion about it. Thank you so much.
Yes, I think these type of provisions are clear indication of protectionism. So, but also they're reminiscent of a period when national courts and some legal systems have been very sort of have a level of mistrust or lack of confidence in the arbitration process. So I think a provision of that level is wrong. I mean, if it's a purely procedural provision, perhaps it's less problematic. And the example I have in mind is Ukraine. In Ukrainian law, you have to apply to the national court to have have the recognition of an investment award. But once you got that recognition in the national court, then the enforcement is almost automatic. Again, there has not been many cases where this did not happen, and simply this seems to have been some sort of a protectionism, but in practical terms, it did not mean anything. Of course, there will be jurisdictions where that protectionism will mean much more, and therefore you will be in a difficult position because you never got to enforce. Yes, is an old-fashioned provision, very. And if there was sort of a reform process, that's one of the provisions that could or should be eliminated. I think the New York Convention, when it comes to the enforcement of the awards, does have the defenses for a state to resist enforcement if they think that the arbitration should not have taken place, and that will be Article 5.1, Article 5.2, A and B. So whether the subject matter by nature should not have been arbitrable or the arbitration has contradicted public policy. So if you have the New York Convention and you are signatory, and you are, I don't think you need an article like that in the jurisdiction. It's just a necessary burden, or even sort of an indication of lack of trust, if you wish.
Thank you so much, Professor Loukas, for the answer.
Okay, for a question also, Joshua. Now, moving on to the second participant. In my screen here, we have Hannah Salvi. So, Anna, you can ask your question.
Okay, first of all, thank you for this opportunity. I want to ask about the finality of the dispute, or about the final and binding on the decision. What if in a prior dispute or prior tribunal, there is a new fact that may affecting their decision? For example, the decision or the dispute was arbitrated by invalid law or wrongly adjudicated by the tribunal. Then will the decision may not be binding, or the only way to make it not binding is just with an annulment? And who may or who could ask for this annulment? Are any other ways to refute the wrongly adjudicated decision on the prior tribunal? So thank you, Professor Loukas.
Yes, I mean, if new facts become available at which have not been available to the tribunal while the tribunal was making a decision, the appropriate person would be a revision of the award, provided that the same tribunal exists, which is not always taken for granted, because once the tribunal has rendered its decision and the period for annulment, which is typically 30 days, has expired, then the tribunal is functus officio, has no longer authority. Now, if, however, within a period of time, new information becomes available, then we can have a revision of the award by the same tribunal, ideally, or another tribunal, or reconstitute the case. Now, what happens if the award has been enforced in the meantime, which can happen? Not much can happen. I mean, if the enforcement was fraudulent, because the party that went ahead with the enforcement knew of the facts but did not disclose them in the process, there might be that additional damages will be paid. But once we have new data, then there will be a revision or a new arbitration. The previous award will still be as good as until we have that new process.
Thank you so much, Professor, for the answer.
Okay, thank you also for the question. And here I see there's two more people who asked a question. Do you still have enough time, Professor, to answer both?
Yes, of course.
Okay, so moving on to the second person on my screen here is Ardin Jillian. So to Ardin Jillian, you may ask your question.
Okay, thank you, Darian, for the opportunity, and thank you, Professor. So this question is based on my curiosity, where, as we know, there are several law systems which are common law system and civil law system. So as my understanding, common law is really broad because usually they relies on practices, while civil law system was based on strict written rules. So basically, there are significant difference between significant in practice between these two systems. So my question would be, do these differences may affect the parties' argument during the settlement or anything there's happened during the proceeding, or is it just depends on their choice of law system? However, if I'm not mistaken, correct me if I'm wrong, you also mentioned that arbitration has no nationality. So can you enlighten me on this matter? Thank you.
Yes, this is a very broad question, obviously. And yes, there are differences in common law and civil law arbitration. Common law arbitrations are overall more party-driven than civil arbitration. So the arbitrators are expected not to interfere very much with the process and let the parties lead the process. This is because our generally speaking, sort of common law systems sees the role of arbitrators as service providers, while civil law systems see the role of arbitrators as private judges, so effectively have a role to efficiency and so on. So, one perhaps big difference is that civil law is a bit more inquisitorial and common law is more adversarial. Now, in reality, if you look at international disputes, even under English law or under French law, they would not look too dissimilar. They would look quite in the way the procedure is organized. There will be some differences about how conflict of laws is approached. There will be some difference about how contract interpretation, for example, I think in English, so in the English process, the contract is more important than law. In the German system or a more civil law system, obviously the law is more important than the contract. So common lawyers look more at the facts, look more at all of these things, and that doesn't seem to be translating everywhere in sort of in all processes. So these are very broad distinctions, and within sort of the distinctions, if we look at civil law from a European perspective, German law and French law are quite different in the approach. German law is more judicial, French law is more softer party power. So some of these generalizations entail a high degree of risk, and it's important to keep that in mind. But broadly speaking, common law, more party-driven, civil law, more arbitrator-driven, and modern arbitration seems to be getting somewhere in the middle.
Okay, so does that answer your question, Julian?
Yes, thank you, Professor.
Thank you again for your question. And we have our last question for today from Michael Del Piero. To Michael, you can ask your question directly.
Thank you for the opportunity. Am I audible?
Yes, you are.
Okay, so first and foremost, I want to thank you for the clear and concise explanations of arbitration, Professor Loukas. So as you mentioned before, the arbitral award is final and binding. I'm a bit confused about the implications of final and binding on arbitral award based on arbitration rules in Indonesia. So if you're looking up in Article 95 of Indonesian arbitration law, it is stipulated that every arbitral award shall be registered to the district court. If the award is not registered, then the arbitral award cannot be enforced. So my question is, do you think such obligations which to register the arbitral award to the district court will eradicate the final and binding of an arbitral award? And the second question is, to what extent is the arbitral award is final and binding? So that's my questions. Thank you.
Okay. I think that the process, again, that there's a requirement to register the award is not unique to Indonesia. I think there are a couple of other jurisdictions where they either have to enter judgment or you need to take an additional act to obtain sort of a stamp from the local court. Or, but yes, I think these are rather domestic processes which undermine the finality and binding nature of the arbitration. Because if you have an award obtained under the law for international arbitration processes, you can typically enforce without that process. And the New York Convention does not require all of these domestic sort of peculiarities to be fulfilled before an award is enforceable. And that's manifested in Article 5.1e of the New York Convention, which is an award may be resisted enforcement if something has not been done in the domestic system, but provided, of course, you have the award obtained and the signature of the arbitrators. So again, that's, I think, some of these elements of protectionism that still exist in some parts of the world and Indonesia, but which are not internationally very common, but are not internationally completely unknown. So again, that's another provision which might have to be addressed as we go forward. There was a question, which is quite a large question in the chat about insolvency or bankruptcy, whether to go to arbitration litigation. So I think that's a very big question that's perhaps a separate topic because it has so many layers. But we've seen a movement recently where the fact that one party becomes bankrupt, sometimes even after the arbitration has started, does not necessarily block the arbitration process. So, but that would require, as I say, a separate lecture. It's a very good question.
Thank you for your answer, Professor. And this has been a great discussion session, but unfortunately, the time for discussion has elapsed. So we finally reached the end of our lecture. But before we close this event, we from the committee would like to convey our gratitude for Professor as our speaker today, who has shared this valuable knowledge for all of us. And we would like to firstly invite Professor Loukas Mistelis to share maybe a word or two as your closing remarks. So, Professor, the screen is yours.
Yes, I mean, one thing that I have made quite clearly is that I think the growth of arbitration is with the younger generation. And arbitration would continue to grow and succeed if we embrace diversity and if we empower the younger generation to take the role of arbitrators and counsel and develop as one would expect forward. So a lot of emphasis has to be put on training, education, and that's the only way, in my view, that arbitration can grow properly all over the world. So the future is yours.
Okay, thank you for your closing remarks, Professor. And now we'd like to invite Dr. Prita Amalia as the head of the department to give a few words of appreciation to the speaker. So, Bu Prita, the floor is yours.
Thank you very much, Darian, to be a moderator for today's lecture. And of course, thank you very much to Professor Loukas Mistelis for very insightful and comprehensive lecture today. And once again, this is a great opportunity for us from the Transnational Business Law Department as arbitration is a compulsory subject for this semester. And hopefully all the students also get a lot of knowledge, and the issue of the arbitration is quite important today. And thank you so much for all the students with your participation as well as all the questions. And Prof. Loukas, hopefully we could arrange another collaboration in the next future. And thank you so much.
Thank you.
Thank you.
Thank you too to Dr. Prita Amalia for your few words. And now, lastly, as a token of gratitude, we'd like to present this virtual certificate as a small token of appreciation for the materials that you've taught us.
Thank you very much.
You're welcome. And maybe if the operator wants to take a few pictures, you may do so now. Okay, so once again, thank you to Professor Loukas Mistelis for the opportunity today, and to all the audience for attending this public lecture. Hopefully all the knowledge gained today may be useful in the future. Goodbye and see you soon in our next public lecture. I'm Darena Marta, and I will now resign as the moderator today. Thank you and good afternoon.
Thank you.
Thank you, Professor.
Thank you, Professor.
See you again in the next future. Thank you. Terima kasih Bu Rita sudah hadir, Pak Jafar. Pak Amir, terima kasih banyak. Izin. Terima kasih Bu Rita, sehat-sehat Bu.